Thanks, Sharita. Welcome back, everybody. My name is Chris Richmond. I am with ICF, and I am accompanied today by my colleague, Les Warner. And we also have a number of HUD staff available to assist us today as well. We have Bruce Haber, Karen Griego, Flora Chavez, and Barrett Fisher. So the way that we run our office hours is we will go over the exercise answers, and then we will see if any new questions had come in through the Q&A box, and if no new questions have come in, we have a list of the questions that came in yesterday, and so Les will start to go through those if no new ones have come in. So glad that you're here today with us. Thanks for joining us. As we get into the exercise, when I scroll down, you will not see my screen change. So if you want to scroll down as well, you're going to want to hover over that gray line that's in between the exercise and the right side of your screen that says panel and chat, and move down the scroll bar to be able to see the other questions. So let's get started. The first question we have today is, what documents must the grantee and the owner have in their files related to the disclosure rule for almost every unit built prior to 1978? Well, I'm going to take us back to the training materials. Let's see if I can find them. There we go. No, that's not it. Sorry. There we go. Slides. So we are going to look on slide 19. That's where you would have found some of these answers here. So what documents need to have? Well, remember that protect your family from lead in your home needs to be provided to the tenant, and there would be an acknowledgement of receipt that they received that pamphlet. You want to have a copy of the disclosure notice with the appropriate signatures and dates, and then if there was any known lead hazards, then there should also be copies of the reports, information of any known lead hazards, or reduction work. So that's what you'd want to have, those three or more things in your files. All right, let's look at question number 2. What does a visual assessment identify, and how can someone be trained as a visual assessor? We're going to go back to the slides, and I think it was slide 28 was where we talked about visual assessment. I must have written the number down. There we go. All right, so someone who's trained in visual assessment is able to identify deteriorated paint. Remember, they don't know if there's lead in the paint or not because they're not using an XRF machine. They're not doing any type of swipes and sending it to a lab. They're clearly just looking around. They're doing a visual to see if there's any deteriorated peeling, chipping, flaking paint. Someone who's trained as a visual assessor, so someone who's gone to HUD's free online training course, there's the link there, can do a visual assessment. This can be the owner, can be the grantee, someone who knows a little bit about properties and standards and construction and has taken that visual online visual assessment training, can actually do the visual assessment for us. All right, let's look at question number 3. Who is responsible for assuring completion of the EBLL response steps, and what is this term called? We're going to go to our slides. Okay, so it is called the designated party. That's who's ultimately responsible for following all of the steps. And for subpart M, sometimes the designated party is the owner, and sometimes it's the grantee. So remember, we had that designated party handout, and here you can actually see at what step does the owner need to do. So the owner is doing initial notification confirmation. The verification is happening by the grantee. Environmental investigation is being undertaken by the grantee. So you can see it depends on what the step is as to who is undertaking that, but it is called the designated party. All right, let's look at question number 4. How many entities need to be notified when an elevated blood level child is reported? And who are they and what is the timing? So this was all found on slide 41. There we go. So there are 3 entities that need to be notified. We have our local health department, unless the local health department is the one that notified you. But if you just found out from the mom who called and said my child was at the doctor's and they have an elevated level, you need to notify the local health department. The local HUD field office needs to be notified, and the HUD Office of Lead Hazard Control and Healthy Homes also needs to be identified. And how you reach out to the Office of Lead Hazard Control Healthy Homes, that email is listed there as well. So HUD does recommend using email. Do not include the child's name or the test results. If you are a PHA, you would want to include the PHA code, or if it's the owner, not a PHA, it would be the owner's name and address, the date of the elevated blood level test, the housing program, is it it's tenant-based rental assistance, what the unit address is, if it's a multi-unit property, the development name, and then whether the PHA or owner has notified the local health department or were you notified by the health department. And this all needs to happen within 5 business days of receiving a verified report. All right, let's look at question number 5. So how do you verify a reported elevated blood level, and what documentation is required? So this, I think, was slide 35. Yep. Okay. So you can actually call or email the medical provider or the health department. Sometimes you'll receive this as the first step, that you'll hear information from the health department. Other times you need to contact the health department or the medical provider to verify that. If there is no initial medical verification that's received, you need to keep records of your attempts that you've tried at least twice to verify that. So you want to have that in your notes. And then if you spoke to somebody on the phone or you emailed, you want to have documentation. If you spoke on the phone, who was the person you talked to, what is their contact information, what is the date, and some notes around that. And then if you were able to email that, you'd want to keep a copy of that email. But all that information is found on 35 and 36. All right, so let's look at question number 6. What is the primary difference between an environmental investigation, that's what EI stands for, and a risk assessment? And who can conduct an environmental investigation? Well, let's talk about an environmental investigation. I think we talk about that on slide 43. Oops. Helpful if I go to the slides. Okay, so an environmental investigation is conducted by a certified risk assessor, and the environmental investigation is a more comprehensive than just a plain risk assessment. So if we were just doing a risk assessment, we would have a risk assessor go and do a risk assessment of the unit that the family is living in. We're doing an environmental investigation, so we're going to do a risk assessment of the unit that family is living in. We're going to be doing a family interview using the questions from the guidelines form. That was 16.1. There's a whole questionnaire there. We're also going to be trying to figure out other areas that the child might be spending time in, either other dwelling areas or space, such as a child care center. So that's going to also be reviewed. The risk assessor is also, for that environmental investigation, is also trying to determine other possible sources of exposure of lead. They're going to be doing a first flush test of drinking water. They're going to be testing glazed pottery or tableware that might contain lead glazes during the interview, and while they're there, they're going to be seeing if anybody that's living in the units or where the child spends time might have exposure from contamination from clothing, or perhaps the work that one of the caregivers is doing is bringing home dust. Perhaps they're a construction worker and they're working in pre-78 units and they're bringing home dust on their clothes. That's a possibility. So they're trying to figure out, are there work clothes or vehicles that might have been contaminated from the parent or the guardian's workplace. They're also going to be looking for imported cosmetics or hobbies or folk remedies, that type of thing. So it's a lot more comprehensive than just a risk assessment, where a risk assessment is they're trying to determine the hazards in that particular unit. The environmental investigation is trying to find the source of where the lead is coming from. So much more comprehensive. I did also want to remind you about the interview video that we have. So part of environmental investigation is doing that family interview. So we do have a highlights video on what are the best actions, what kind of tone needs to be taken with the interviewer, what are some of the questions, how to handle that situation. So it's brand new. So please go take a look at that if you have a chance. And then the HUD guidelines I mentioned, here's the link for those HUD guidelines. So Chapter 16 of the HUD guidelines reviews more in depth about an environmental investigation. So let's look at number 7. If lead hazards are found in the index unit, so remember our index unit is the unit where the child with the elevated blood level lives. So if lead hazards are found in the index unit, do all the coverage units need to be inspected? Remember, our coverage units are units in the property that are federally assisted, that have a child under 6 living in them. So if the index unit has lead hazards, do all the other coverage units need to be inspected? How soon do they need to be inspected? And what type of inspection needs to happen? So we're going to go back to the slides, and I think it's 55. Yep, so we're going to be responding to our other coverage units. We need to be doing a risk assessment. Here it is. So it wasn't 55, it was 56. And we can be doing a sampling. So we don't have to do a risk assessment of all of our other coverage units if we have a certain number of coverage units and it's a certain year that the project was built. So if we have properties built before 1960 and we have more than 20 coverage units in that property, then we can do a sampling. And if we have properties between 1960 and 1977 with more than 10 coverage units, we could do a sampling. There is a chart, 7.3 in the HUD guidelines, and that is what you can follow for the sampling. The risk assessor, the one who's actually doing the risk assessment, will be helping you identify that sample and how to do that sample. So remember the HUD guidelines. There's the link there for the HUD guidelines. Again, that's table 7-3. So you would go to chapter 7 and find table 7-3, and that talks you through the sampling. And then on slide 62 is the timing. So with risk assessment of these other coverage, well, first we have the hazards in the index unit. So the hazards in the index unit have to be addressed within 30 calendar days of receipt of the environmental investigation. And then the risk assessment of the other coverage units, if we have less than or equal to 20 other coverage units, that has to be done within 30 days. If we have greater than 20 other coverage units, the risk assessments need to be done in 60 days. If we did identify lead hazards in our other coverage units, then we have interim controls. That's our lead hazard control treatment that needs to be conducted. That needs to be done within 30 days for a property with less than or equal to 20 other coverage units, and 90 days for a property with more than 20 other coverage units. All right, let's look at question number 8. If there were no lead hazards found in the other coverage units, does a designated party have to do anything else? Let's look at our slides. We're going to go to slide 67, I believe. Nope, it's 61. I can't even read my own notes here. Okay, so if there were no lead hazards found in the other coverage units, then we still need to notify our residents who are in our coverage units. Because remember, our risk assessment was done in those units, and so they're going to want to know what happened. So we'll notify them no lead hazards were found in those other coverage units. And so the elevated blood level response is now complete for our other coverage units. We still need to do interim controls for our index unit. That's the unit where our child living with the elevated lead level resides. We did find hazards in the index unit, so we still need to do our lead hazard control in the index unit. But if we did not find any hazards in our other coverage units doing those risk assessments, then we do not need to do any lead hazard treatment. We provide the notification, nothing was found, we document the file. All right, let's look at question number 9. When is lead hazard reduction work considered complete? That's 67. So all lead hazards that are identified during the investigation should be eliminated or controlled. And then when the unit passes clearance, that's when it's considered complete. So clearance includes it's 2 parts. It's a visual assessment to determine completion of work in the absence of hazards. It's also accompanied by dust sampling, and those dust samples are then sent to an accredited lab to measure the residential lead dust levels. Those results are then interpreted, and they are put into a report, which is the NOAA's lead hazard reduction activities, which would identify that it had passed clearance. If for some reason the unit fails clearance, the work site has to be re-cleaned, and then another clearance test is conducted. There needs to be an hour waiting period between re-cleaning and then retesting. And then if additional work has to happen, that might be the case as well. All right, let's look at our last question, number 10. What actions are needed after clearance is complete? Well, I think we have that on 70. Go back to my slides. Right, so we have to, if clearance is completed, a notice of lead hazard reduction activities needs to be provided to the residents. This needs to be provided within 15 calendar days to the property residents. And then notification to the local HUD field office also needs to occur. That has to occur within 10 business days to the local HUD field office. After that's all done, we also have ongoing responsibilities, and our ongoing responsibilities are called ongoing maintenance. So for Subpart M, our ongoing maintenance is a visual assessment, again, done by someone who's trained in visual assessment, that free HUD online training. And that needs to be done at unit turnover or every 12 months, whichever is sooner. So we do have ongoing maintenance requirements. So that's our last question in the exercise. Is there any questions that came up as a result of the exercise, or anything you want to expand upon?
Well, it's not really as a result, and it ties into a question that I'm already going to go ahead and cover from yesterday's question. So I think if you want to hand over the
sure.
Controls, I will take us to the slides and kind of talk through. So we always go through the questions that have come up in the prior session, partly just kind of looking for trends and kind of key issues we want to sort of revisit, and we have a little bit more time. But also, I think for a lot of folks, keeping and listening actively in the session and monitoring that Q&A box might be a little bit of a challenge for folks. So the question that we've gotten today, and let me find the right handout. So let me clear the notations. All right. So we had a lot of questions that came in yesterday on this same topic that all relate to, I can tell folks are thinking about, who's going to be responsible for what, and also who's paying for what. So we had a question about, with the environmental investigation, who's going to be handling that and who will be paying for that. So if we kind of scroll down here, and this is under Subpart M for tenant-based rental assistance, we have a chart that walks us through all the key steps on this. So specifically, the question was asked about the environmental investigation. That's going to be handled by the PHA or the grantee. So they're not only going to be responsible for having that completed, but they would also be paying for that to be completed. And that kind of relates to, we spent a little bit of time yesterday talking about sort of planning ahead and thinking about, okay, if I need an environmental investigation to be completed, we have specific timelines on that, that we're going to then need to, plan ahead, have completed procurement, so that if we then need to task the risk assessor with completing this environmental investigation, that we're ready to be able to do that, so we can try to meet those timelines on that. So you'll see on this, and just to kind of quickly walk through this. So the initial notification of that confirmed case going to HUD, and we also mentioned about the that's not only the Office of Healthy Homes, but also your field office and the health department. That would be the responsibility for the owner of that property. But keep in mind that we kind of have this, you always have this oversight requirement as the PHA or the grantee. And so wanting to make sure that all these key steps have been completed, I think the PHA or grantee are going to want to be able to track to make sure that these steps are being completed. And then, so we talked about the environmental investigation is going to be handled by the PHA or grantee, but then the actual lead hazard control work that would be done as part of that, and then also looking at the other covered units, would be the responsibility of the owner. So we're going to want to make sure that we're kind of keeping an eye on making sure that that work is being completed, that we're getting clearance completed as part of that, that notification has been completed. And then we talked about ongoing maintenance, where we're going to be doing a visual assessment, not only on an annual basis, but also a turnover on those units, to make sure that those units continue to be lead safe for those tenants. So I pointed out yesterday, sort of this bottom point here is that for the things that are in this column for the owner's responsibility, the PHA and the grantee are going to need to make sure that they're providing appropriate oversight to make sure that those steps are happening. And I think that would probably need to start with on the front end of projects. I would think that a lot of you, I know in the TBRA programs that I worked with, we had an agreement not only with the tenant, but there was also an agreement with the property owner that was going to be receiving these tenant-based rental assistance payments on behalf of that tenant. And that agreement with the owner spelled out, the requirements that they were going to need to follow, including this response when we have a child with an elevated blood level. So wanting to make sure in the front end that they understand these requirements. You could certainly assist them. So for instance, these questions that, okay, with the lead hazard control work, identifying a contractor that has the appropriate certification, that owner may need your assistance on being able to identify the pool of available lead contractors in your area, knowing the certification that they should have in their file as part of that. And so I think that oversight doesn't necessarily mean, when we talk about monitoring, waiting till it's all over and completed and then checking to see if it's been done. There's probably some coaching along the way, which maybe starts with if you're executing a written agreement with that owner that's going to be receiving the tenant-based rental assistance. So that was the question that we got today about who's responsible for the environmental investigation, who will need to pay for that. Yesterday, we also had questions about who's responsible for the lead-based paint disclosures, also asking about confirming who's going to be the reporting party. And so under Subpart M, this is the chart that you would be following. There is a second page to this document which provides you a flow chart and kind of walks you through this process. So I think this would be one of the handouts that I would encourage you to print out, have a copy available. They also are, I think they were in your packet that you were provided, and these are also some of the tools, I believe, that are posted on the website. Chris, any new questions that have come in, or shall we keep? That doesn't look like.
No, I don't see any new questions. So please, if you have any questions, go in the Q&A box and type them in, and we'll be happy to answer them.
All right. So one of the other sort of common areas that we saw in yesterday's session was talking about sort of responsibilities on disclosure and also, this didn't get me what I wanted. Let's try this. There we go. We're talking about disclosure and some of the exemptions. So I kind of wanted to go back over this. So when we're talking about compliance with not only the lead safe housing rule, but also this protocol for working with an elevated blood lead level specific to Subpart M, keep in mind that our target for this is our target housing, and that's going to be housing that was built prior to 1978. So we talked about the fact that in January of 1978 is when the ban on residential use of lead-based paint. And so these rules are going to apply. So when we talk about disclosures that need to happen, our visual assessments, all of this is going to be for target housing built prior to 1978. So we had a question yesterday about, if I have a child that is visiting a unit that was built prior to 1978. Well, Subpart M is dealing with where we have tenant-based rental assistance that's being provided to this tenant who's living in this assisted unit. So our focus is specifically on that assisted unit. It would not apply then to, if the child is, maybe spending some time at grandma's house. Now, when we get into our environmental investigation, in the point that we have a child with an elevated lead level, as Chris mentioned, that environmental investigation is looking beyond just the unit itself, looking at other factors within that unit, but also the environment that that child is exposed to. So, if that child is spending time at grandma's house and grandma's unit has lead, that may be something that would be looked at as part of the environmental investigation. Let's see, we had a couple of other things that were related to this same question. So as part of this question, you'll notice that we say with some exceptions. So we do have some pre-1978 units that would be exempt from this. And the one that we had the most questions about was this issue about housing for the elderly or a residential property that's designated specifically for persons with disabilities. So the key here is that this is not based on the actual occupancy of the unit. So, we could have undesignated units that had elderly occupants. They are not exempt. This is only where the unit itself has been restricted on occupancy, has been set aside that so it is specifically only for the elderly or persons with disabilities. And so the presumption here is that if these units are specifically restricted to the elderly or disabled, that we don't expect to then have a child under the age of 6 that's residing in that unit because they have been restricted or designated in that way. And so the note here is important that, in some cases we may find that we've got a restricted unit for the elderly, but maybe they've taken custody of a grandchild. And so we now have a child under the age of 6. In that case, that waiver that we had in place so that the lead safe housing rule didn't apply, that goes away at the point that exemption doesn't apply if we find that even though it's a restricted unit, we have a child under the age of 6 that's actually residing there. So we had a couple of questions that came in yesterday where folks were asking about, well, if this unit houses elderly folks and they have no children, does the lead safe housing rule apply? Well, the issue here is not on, are the occupants elderly? It's, is this a restricted unit? So if it's not a restricted unit, the fact that we have elderly individuals occupying that unit doesn't waive or exempt that unit from the requirements. And so we would still be providing disclosure. We would still be doing our visual assessment on this as part of our compliance with the lead safe housing rule.
Okay, Les,
yeah.
we did get a question that came in. Somebody was asking.
Let me do, if you
yeah.
don't mind, there's one more that's sort of related to the same thing.
Oh,
so,
sure.
Hand in hand with that, with this exemption, is this issue about, do I still need to do disclosures? And so we also had a question about, would there be property? So for instance, we get a lot of questions, well, I have a property that's assisted and it's a unit that was built after 1978. So that unit's going to be exempted from the disclosure requirements because it's not one of our target housing units. And then I think Chris walked through yesterday about the fact that we may have some properties that we have done testing and we've determined that they are lead free. So this could be, a unit that was built in 1965, for example. We've done testing, we found that they're lead free, and so they would be exempt from that disclosure rule. We'd have to have that documentation in our file to be able to show why we were not required to do disclosure on that. All right, so Chris, lead us into the next question.
Sure. So the person asking the question was asking about tenant protections, and if the owner decides not to be compliant with the program and chooses to terminate the tenancy due to the newly engaged requirements or the response to an EBLL child. So it is a violation of the Fair Housing Act to evict a family from a home as a result of an EBLL child, so that you have that law to support you. But then when a property is determined to be the source of lead exposure, that property is now in violation of whatever standards your program is following. So are you following HQS, your housing quality standards, or the Uniform Physical Condition Standards? So now that there's lead exposure, that is a violation of the property standards. And so property owners who choose not to bring their property into compliance with either HQS or the UPCS codes forfeit those terms of that voucher or the housing assistant payment contract, and then the family is going to have to relocate because they're in violation with your program requirements, your property standard requirements. Les, anything else you want to add to that?
Just, obviously we're going to assist that family in relocating. And I think that's one of the reasons that I know the programs I worked with we had that agreement in place with the owner of the property who had a tenant that was going to be receiving tenant-based rental assistance, because that, you know, they were signing on this, that they agreed to these terms and requirements, and then that was helpful in that sort of enforcement process where we're saying, okay, you're in violation of these regulations, and this is why we're going to be terminating that assistance to your unit and working with your tenant to assist them to move somewhere else.
Great. That's about it right now. Were there others that came in yesterday to expand on?
Yeah. So let's see, we've got a number of these. Okay, so we had some questions, which, you know, when we've done these trainings in person, a lot of discussion on the data sharing. And, you know, with practitioners in the room, some very different descriptions of how that was working for folks. So there was a question yesterday saying, are health departments required to participate in the data matching and sharing? And so Bruce responded to this yesterday, and I wanted to make sure that folks saw this and kind of draw this out a little bit. So, you know, Bruce responded saying, you know, health departments across the country have various privacy rules that they must follow. So, you know, HUD doesn't really have a way to enforce what the health department does, but you, as a recipient of funding that are triggering under Subpart M, this requirement of data matching or sharing, need to be able to demonstrate that you are following that process. So it's a voluntary exchange. You would be documenting that you are making contact with the health department, that you are providing that information, trying to have that coordination happen. Whether the health department either actively provides you information or you are simply sharing with them the list of assisted TBRA addresses, and that you're hoping that the health department is going to cross-match those with children that they've been able to identify with elevated blood levels, so that you know, we could use this as a trigger to know where these protocols in assisting those households, you know, we hope that they will use that information that's being provided and actively participate, but we don't really have a way to enforce that. Let's see, there was another question related to that. So there was a question about, you know, do we know whether this is actually being complied with? And I think part of that was knowing, you know, what are the health departments actually doing with this. So as part of the monitoring of a grantee or a PHA's compliance with Subpart M, you would need to be able to provide documentation that you are following these requirements. And we mentioned yesterday that in the toolkit under Subpart M, there are some sample forms that could be used in making that contact with the local health department and sharing the information that's required under this. So you're going to want to have documentation that on your part of this requirement, that you can document that you are following those requirements. You don't really have a way to be able to document necessarily whether the health department is then taking your information and responding back to you, but you would obviously be showing that you have done what you can to comply with these requirements.
So Les, there was another question that came in. We were talking about the restricted units, restricted meaning units that were specifically for the elderly, or units that are specifically for the disabled, unless there was a child under 6 living in those units. Did they still need to do a visual inspection for lead? And the properties that have these tenancy restrictions are exempt from the lead safe housing rule, and exempt units do not require visual assessment for lead or deteriorated paint at HQS inspection. So documentation is the reason why the lead safe housing rule does not apply. It's what's required. So you would have information that this property is specifically only for the elderly or only for the disabled. That's what would need to be in the file.
Great. All right, so let's go. We had a question that came up yesterday about, and I think this is probably a little bit confusing when you look at this slide. We talked about that the definition for an elevated blood lead level is 5 micrograms per deciliter or greater, but then we have this notation that the CDC has recently lowered their definition on this, or their reference point, to 3.5 rather than the 5 that we're currently working with. So currently the HUD requirement on this is the 5 would be the definition that we're going to be working with. Now, I will note, and we kind of mentioned yesterday, that some of you are working where you have a state program, and you might have some more restricted requirements, so you may want to check and see if you have something more restrictive that applies to you based on location. But for now, the requirement remains at 5 micrograms per deciliter and has not dropped to the 3.5 that the CDC has more recently adopted. Let's see. So there also was a question yesterday about saying, in the community that they're working in, that there are few lead contractors, and a concern about, we have this requirement that when we have an elevated blood lead level, that after our environmental investigation, that we would have that work completed within 30 days. And so the concern was, I may have difficulty meeting that timeline. So a couple of things just to remind you of, one way to verify what firms are in your general area, and don't necessarily search just for your town or your particular county, but in that surrounding area where it would be reasonable. We oftentimes have certified contractors that are traveling some distance to be able to take on projects. But also we made the suggestion about if you have home or CDBG grantees, if they're doing any kind of housing activities, they probably are triggering compliance with lead safe housing rule, and may have a pool of identified contractors who are available in your area already, working in your area. That might be a good resource. We also mentioned where we have hazard control grantees. These are folks receiving a HUD grant that also would probably have a pool of contractors that are working in your area. I think in the sort of bottom line advice that was provided yesterday was, your goal here is to try to make sure that you are getting as close to the required timeline as possible. And so, we were encouraging you yesterday on trying to make sure that as part of your sort of pre-planning on this, that you would try to identify where you had appropriate firms that would be able to do that work, whether it's you as a grantee or a PHA are going through procurement on that, or you would be helping owners identify firms that could potentially do the work in your area. And if they were firms for the environmental investigation, or if you were going to be contracting for lead hazard reduction work, thinking about going through procurement in advance of that, so that you aren't adding that to your timeline to be responsive to these requirements. Okay. I will also mention, we had a question yesterday that was kind of asking about, well, how does this all work in the case where we have a sub-recipient? So as Chris mentioned yesterday, we're going through the requirements that grantee or PHA is responsible for, but in some cases, that grantee will be working with a subrecipient who is operating all or part of a program on behalf of that grantee. And so in those cases, the grantee has the ability to assign some of those responsibilities to that subrecipient. And so if the grantee is doing that, they need to make sure that not only the subrecipient understands what those requirements are, that they have sort of policies or procedures, implementation plan in place to be able to do that, and then providing adequate oversight to make sure that that's actually happening. As Chris pointed out yesterday, when HUD comes to monitor the grantee is who's going to be held responsible for being in compliance with these requirements. So when you're working with the subrecipient, which is a great way to be able to have adequate capacity and implement projects and programs, just making sure that you have those systems in place and that you are actively providing oversight to make sure that what you believe the subrecipient is going to be completing on your behalf is actually happening. I'll also mention, so there was a question that came in the chat box yesterday. Just clear the annotation here. There was a question that came in yesterday about, they were thankful for the resources that were provided about this, but they were asking for, is there any additional guidance on abatement? So one of the things I wanted to point out, we mentioned this yesterday, but one of the resources here is the HUD guidelines for evaluation and control of lead-based paint hazards in housing. And so this contains individual chapters that are topic by topic. So both Chapter 12 and Chapter 13 relate to abatement. We also have some interim guidance that has been provided on a topic-by-topic basis, which also would be, I think, helpful in kind of, making sure you were aware of all the current guidance that related to abatement. So we showed you as part of this resources that there is a landing page on the HUD Exchange which provides information about kind of everything related to lead-based paint. And then we highlighted that one part of that is this lead-safe housing rule, and then that is kind of divided into topics. On that, this is where, based on looking at Subpart M, that you would be able to pull up some of the standard forms that we talked about that. So if you've not spent a little time and become familiar with that, I would recommend that you do that. We also mentioned as part of that that we have a number of videos that are available that would be, I think, very helpful for folks. And then we also mentioned about signing up for the HUD Exchange and indicating your preference that lead was one of the topics that you were interested in, that you needed to stay current with. And this would then give you notification as additional trainings come out where that would be helpful for your staff or other partners. It would also, as additional tools or guidance was provided, that would be available to you. Chris, that's really from yesterday's summary. I think that kind of covers things. Do we have, I don't see any other?
There was a question or clarification that came up, I think it was in the chat, when we were talking about housing exclusively for the elderly, and they wanted to know, well, the child's not living there, the child's only there for a couple hours, to visit or for grandma to watch the child, and we're really looking for where the child resides. So where does the child sleep at night? Where are the majority of their belongings? Where are they, where are they sleeping is really the definition we've been using for where they reside. So that having the child there a couple hours a day does not count as residing in the unit if it's elderly housing. And then there was another question that came in last. I don't know if you saw that, the very last one.
Is this about the local health department?
Yeah, and the different results.
So in this question, the question was about local health departments not sharing the exact EBLL, that it just states that it was above 3.5, which is the CDC level that we were talking about. And the question was, is HUD okay with them going ahead, addressing these following the full assessment requirements when, the trigger on this under Subpart M is currently at 5, and these might be, based on the notification, since I'm not giving you the exact information, might be perhaps below that 5 because they're reporting based on the 3.5. So, Karen was suggesting, first making contact with the parent or guardian, because we do have this requirement on verifying that we have a elevated blood level with that child. So if you're getting that information from the local health department, the parent or guardian may be able to disclose to you whether that venous test result was 5 or above, so you would be able to know on the trigger on that. But I would also think that you could, as a program, choose to respond to 3.5 or above, that you always have the ability to be more stringent. You are required by regulation to meet the minimums on this, but you could adopt a more stringent standard. So I think that would be another option for you on that.
Great, thanks, Les. Those are the last questions that we have.
Okay. So, we've revisited about the resources. Chris, do you want to mention the upcoming other EBLL training session on that?
Sure. So this one was specifically for Subpart M, for tenant-based rental assistance. We are doing a training, I think it's December 6th, for project-based assistance in public housing, so following Subpart H and Subpart L. A lot of the response is identical. It's just what for the regular overview of lead, there's differences there. Ongoing maintenance is different, but the majority of the training is similar. So that's why we split them as 2 separate trainings, not thinking that you would go to this one and the other one. You might find it a little repetitive. But that one for project-based assistance, so you have colleagues that work in project-based assistance or public housing, that's going to be December 6th, and then the office hour session will be December 7th. Les, maybe we can put, I think there's one of our pages that has the email in case people have follow-up questions.
Yes.
There we go. At the bottom.
So at the bottom of the page here, and we've already got your little sticker there. Where Chris has her little sticker on the bottom here to contact the Office of Lead Hazard and Healthy Homes. So we have an email address here. So as additional questions come up, obviously we were suggesting you use some of the resources, but you also have the ability to contact the Office of Healthy Homes and ask questions and seek additional guidance. And so I think that would be something good to hold on to going forward also. And I would just point out that, in the resources that we provided here, that there are some prior recorded trainings on the other subparts. And so, some of you are operating multiple programs that would trigger different subparts of this, and just be aware that there is additional training that is available that's posted on the HUD Exchange. think that's all I've got, Chris.
All right. Well, thanks, everybody. Thanks for joining us today. Thank you, Les, for going over all those questions, and for Sharita for hosting us and helping everybody with those tech issues. Thank you to our HUD staff. We had Bruce and Karen and Flora and Barrett on today, so glad that they were able to help answer questions today as well. So thank you for your time and for attending, and please check out these resources. Hopefully they will help you as you move forward with your jobs. So thanks, everybody, and hopefully we'll see you again in another session in the future. Bye.
Thanks, everybody.